The Verdict is a live broadcast, and the opinions expressed by the host, guests, and callers are not necessarily those of this station. The references to legal matters are based on actual cases filed in federal and state courts and are matters of public record. Every legal situation is different, and none of the information or views provided during the taping of The Verdict are meant to be legal advice. For more information about The Verdict, please visit us at www.theverdicttv.com. Hello, and welcome to The Verdict, a show where lawyers take you behind the scenes as they prosecute the most action-packed legal cases around South Florida and New York. The Verdict is all about powerful insight and analysis about how to put the law on your side. If you want to call in, you can reach us at 888-565-1470 or write us on Facebook at The Verdict. Now, let's get down to justice. Here comes The Verdict with your hosts, Jay Farrow and Janine Davis.
And good afternoon, everybody, and welcome to The Verdict. I'm your host, Jay Farrow. The show is taking you inside the law like never before, inside cases that don't necessarily find their ways to the mainstream media. We're going inside those cases to take you to a real-life view of what's going on with real lawyers and real people. Purpose of the show is to really dig deep, so how the law can work for you. Even though you don't think that you have a voice in the law, you do. And we're here to show you how to do that. We're show you how to get in and get your hands dirty and really give you some helpful tips. As at the last part of the show, we're going to give some tips about how entrepreneurs could use the law more effectively to support their businesses and save a bunch of money. I think that the advice that I'm going to give later on in the show could possibly save you millions. So you want to stay tuned to the last portion of the show.
Good afternoon, everybody. I am your co-host, Janine Davis. And yes, stay tuned with us. Stick with us till the end of the show because we've got some really amazing, life-changing topics and tips of the day. So every last segment of the show, you will receive a little nugget that you may not have known before. And again, the show is for sure to bridge the gap between the law and your life, and to do so in an engaging and powerful way, and also to really kind of educate. So if you have questions, if you have anything that comes up for you, anything concerning the law, please do not be shy. Call us at 888-565-1470. One day I'll get that number right.
I'll tell you what. I mean, I created the show because I thought that the law is a mystery to most. And not just a mystery to most, but inaccessible to most.
I think also I would go as far as to say the law is a source of fear. I think some people are interested in the law intellectually, but they never want to be involved in it directly, right? They don't want to be on either the plaintiff or the defendant's side, right? So you don't want to find yourself in the thick of it necessarily.
Now, most of my clients and in my law firm I find themselves have been bullied.
Yeah.
Bullied in the workplace.
Yeah.
Bullied in other ways where their partner ripped them off. I mean, in a number of different scenarios.
You did foreclosure for a number of years. So that's actually clients being bullied by banks.
Yeah, I did foreclosure back in the day
huge.
When foreclosure was foreclosure. When I say that, back in 2008, when the financial crisis hit, I decided that the homeowners were going to need some help, and that the banks had lawyers working hard on their side. What about the homeowner? Because back then, overnight, if everybody recall this, back in 2008, the financial system was on the verge of collapse, or it did collapse.
Right.
And the housing market here in South Florida, actually,
was the hardest
hit area in the country, where the three counties, Broward, Palm Beach, Dade, Fort Myers, and actually Fort Myers in the city of, I think, Lee County, and this place called Lehigh Acres, the hardest area hit in the country, except for Las Vegas.
So let's talk about that for a second, because I want to give people a historical perspective. What I mean, obviously we had The Big Short, right? We had that huge crisis and everything sort of collapsed. But what made this housing market so vulnerable, do you think? Like from the legal side, right? We're not looking from but what did you see in the trenches?
I saw.
I want people to understand what they could possibly avoid in the future.
I saw that the real estate market was down here. It's a place to retire. It's a place to vacation. I mean, it's a place that people dream about living. And, with the 24 hours a day, 7 days a week, 365 days a year, where you can go to the beach.
Yeah.
So it's one of those places in the United States that's just suited for a really good real estate market.
Absolutely.
And I don't, and most of my clients I knew at the time, I mean, before they were even my clients, I knew people that are making a lot of money in real estate, buying and flipping, buying and flipping, buying and flipping.
Okay, so a lot of these people were investors and not necessarily.
I wouldn't call them investors. I'm calling it amateur investors. I mean, people thought that real estate was like going to be like this thing.
Sure.
It was like the next bubble of the stock market. If you remember, like the .com bubble.
Yeah, of course.
This was like there was a bubble down here, and real estate. Listen, I bought my house in 2005 down here, and I thought it was going to go to the moon. It was new construction. It was downtown Fort Lauderdale, and I thought that this thing was going to make a couple $100,000 in a couple of years, and it was going to start me on my track of financial security.
Sure.
Because really, that's what I was looking for.
Well, but this is the American dream, right?
Right.
And this is why I think it's such a vulnerable and important topic to bridge, because you're dealing with one of the largest investments a person will ever make in their life is their home.
But okay, so if we're going to talk about foreclosure, I want to show you why this show is so impactful.
Yeah.
Because in the foreclosure market, I want to show you that back in 2008, nobody knew. Foreclosure was like this. You didn't pay your mortgage, you're going to get kicked out of your house. Right. But what we didn't anticipate was the games that Wall Street were playing with all the mortgages. Even when I got into the idea of representing homeowners in foreclosure, I mean, I was drawn to it because it was the David and Goliath story of all time.
Right. So this is a consistent theme in your law practice, right? Because David and Goliath shows up everywhere, and we'll get to that later on too. And again, excuse me, Jay, just want to give the call to action for people to call into the show if they have questions or curiosities or want to make a comment of any kind. Again, the number is 888-565-1470. That's 888-565-1470. And for those of you wondering why I'm looking back, because the number's on there, and that's why I'm looking back. But okay, so please talk to more. Educate us.
It was a David and Goliath story of all time, right? You had mom and dad, mom and pop. All right, that got their first mortgage, or I mean, listen, I got my first mortgage. So let's say mom and pop are the first time home buyer, buys their first house during this time where there's this bubble, right? So what ends up what was really going on was that Wall Street was betting against subprime loan market.
Right.
And so anybody with a heartbeat and a 500 credit score was getting a loan for some $500,000 in 2005. I was one of those people that had a higher credit score than 500, but I got a loan for $500,000, just about $500,000.
Right.
And 3 years later, I was on time with all my mortgage payments. 3 years later, to the day, my mortgage rate adjusted. And when my mortgage rate adjusted, it went up 3% overnight. At the same time, this was March of 2008 now, that the value of my house basically lost 40% of its value almost overnight. So I was faced with this issue as hundreds of thousands of people. It's like, okay, I'm going to continue to pay a mortgage, and I'll never ever see the value in my house. I'll never have equity in my house.
It's called underwater, right?
Completely underwater.
Completely
so
underwater.
I called the mortgage servicer at the time, and I said, "Hey, what's the deal?" You know, and I made them an offer. I was like, "Here's what I'm willing to do. Why don't you cut my interest rate to this?" And they weren't hearing it. They were like, "Absolutely not. We're taking anything off." So I had a decision to make at that time because I really couldn't afford. Actually, you know what? I was taking money out of my credit cards to pay my mortgage. That's how desperate I was. I was in panic.
Yeah.
Because here I am. I mean, this is my first home. I cannot lose this. And finally, I got to the point where this is just absolute insanity. And I stopped paying my mortgage because I had to do the math. I mean, I could not afford what was going on, and
so you're speaking vulnerably about something that happened to you, but really it happened to so many
hundreds
families,
of thousands of people,
hundreds of thousands of people.
And this was
in the same time.
This was by design. This was set up to fail.
This is really what you don't know really hurts you.
Right.
And this is also too that we've experienced in the law firm where the fine print the devil really is in the details, and the devil will cut your throat overnight if you're not careful. When that arm adjusts, it is brutal. We talk to people. As a part of what I do at the firm as client services, I sometimes facilitate calls between the law firm and the client with the bank, and it's absolutely brutal. I'm shocked at the end of the call every time.
So I'm not paying my mortgage, but I'm doing research. I'm like, something's not right here.
Right.
Because I'm not the only one. And then my neighbor.
Right. It's not an anomaly.
Starts talking about it. And then I started going to some seminars, and I ran into this woman. Her name was April Charney, and she was out of Jacksonville Legal Aid. And she was giving seminars talking about these securitized trusts. Now, I had represented bankruptcy trustees as an arm of the bankruptcy court, so I knew a little bit about, what was like a little bit what she was talking about. But I started to read more, and then what ended up happening is like nobody was actually owning these things, because the transfers, no one could keep up with them, so nobody knew who was owning all this property. So I started to represent people. Now, you want to talk about David versus Goliath story. Now, mortgage foreclosure used to be, you didn't pay your mortgage, you're going to get kicked out of your house.
Yes.
Okay, so I started representing clients in 2008. I started to dig deep into these cases. I started to become obsessed with how did the transfers happen. How is it possible that
forensic investigations?
I was doing forensic investigations just like I was doing when I was representing the bankruptcy trustees, chasing dirty money. Because basically what I was ended up doing was I was chasing a trail of dirty money in foreclosure. All right, and so as time went on, I started to win some of these cases. And 2 years later, in 2010, Bank of America suspended their foreclosure practice because they recognized that the law firms down here were stamping things on notes, and they were filling out affidavits.
What was called the robo-signing scandals
issue.
Back then.
So back
correct.
in 2010, 2011, and 12, these cases became winnable. When I say a foreclosure case was winnable, that was unheard of. Mind you, this was like the Wild West back then, because nobody knew what was going on. There was hundreds of thousands of cases being filed. Now, I remember going to the courthouse, and people with stacks of stuff. I mean, thousands were getting filed a day. I mean, I had 3 people in my office a day. How can you help me? And as time went on, when I first started the practice, I said, I can probably promise you maybe like 12 months before something goes to trial. And then the next year went, and the next year went, and the next year went, and then all of a sudden,
longer and longer.
I started to not only win some of these cases, but recognize some of these cases are taking 5 years, 6 years.
Oh my goodness.
Okay.
So this is 6 years with the homeowner in their home and not necessarily paying their mortgage, correct?
No.
What's a win? Explain to us.
Okay, so
how do you consider a win?
So it used to be when I got these cases originally. So
it's important that you create this distinction of what used to be, because we're going to talk on the other side of the break.
This is a big deal.
How this may pertain to you today, because unfortunately, foreclosures are still happening.
But
thousands
if
daily.
we're going to be going down this road, I'm going to show you how the foreclosures actually turned into potential RICO cases. When I say civil racketeering cases, I'm going to show you what is ended up happening today. But I'll take you through the litany of what's happened and why it's so important to keep up with what's going on with the Florida Supreme Court, what's going on in the Florida legislature, and what's going on with your local judges. Because believe it or not, the circuit court judge in your county has more power over you than any other politician. I'm going to say politician because they're elected officials. That any other elected official, I should say, will ever have over you. And if we're going to go talk, foreclosure is a perfect thing to talk about the David and Goliath story.
Yeah, we're going to take our first break, but stay tuned with us, because again, bridging
this story is
the
compelling.
gap.
You're going to love this story. Is
Bridging the gap
unbelievable.
between
What's happened
the law,
in this area,
what happens in the circuit court, and how it affects you on a daily basis.
The twist that's happened now will shock you.
Yeah.
I'll see you on the other side of the break.
See you on the other side.
Farrow Law Firm, standing up to corporate bullies, using innovative, aggressive, and effective strategies to resolve disputes effectively and timely. Contact us at 954-252-9818, online at farrowlawfirm.com, and on Facebook at Farrow Law Firm. We look forward to being of service to you. You have been watching The Verdict with Jay Farrow and Janine Davis. If you want to call into the show, you can reach us at 888-565-1470 or write us live on Facebook at The Verdict. Now, back to the verdict.
Good afternoon, and thank you for returning back with us. I am Janine Davis, your co-host, here with attorney Jay Farrow. And before we went into break, we were talking about the twist on foreclosure, the David and Goliath, and how any of this actually could pertain to you. So speak into that, please.
And I want to underscore all of this about this David versus Goliath, because you think that you don't have a voice. My clients that were going through foreclosure, I've represented hundreds of them throughout the state of Florida and in New York. You think that you don't have a voice. But what ended up happening was, because of all of the stuff that was going on in Wall Street, we started to uncover all of the fraud. And we started to win foreclosure cases. Now, to win a foreclosure case is to show that, in some instances, that the plaintiff didn't have standing or the bank didn't have standing.
What does that mean?
It basically says that under Florida law, they have to have physical possession of the promissory note, the original promissory note, at the time of the filing of the complaint.
Because the promissory note says what? Because that they actually own the note.
Because that's ownership of the loan. Okay? And so there's 1,000 issues. It wasn't just that you didn't pay your mortgage. When you start digging deep into cases, you become more resourcess. In my foreclosure cases, when I was looking at them forensically, you now had this issue of, did the bank have the original note at the time of the filing of the complaint? Then, did they comply with all the conditions preceded? There's a lot of things that banks have to do, and if they don't comply with them, they can't file a foreclosure case. And this was so if imagine this, if a bank couldn't prove that they were physically holding, or someone that they assigned to physically hold the note at the time of the filing of the complaint, they couldn't prove their case. The same thing if they didn't send certain letters to the debtor, then they couldn't prove their case.
Right, because for an industry that is so heavily regulated,
imagine this.
At the end of the day, they get away with murder.
Imagine this. I had a 4-day trial on a foreclosure case. Now you think,
how could that even happen? How does that happen?
Because because that particular loan had been securitized. The amount of evidence was like from the floor to here, and it came down to whether the bank sent or mailed something out. Now ultimately that case went up on appeal and it got reversed. And I won it at the trial level, and I took that case up to.
How could it be reversed if you won it at a trial level?
No. So you go and that's a good question. That's a good question.
Because I'm telling you, people at home do not understand how that could even happen.
You know what? I'd like to give you a really good answer for that, but ultimately the appellate court just felt like that the trial court got it wrong after a 4 or 5 day trial. I want to say like this. Listen,
I'm just saying. I'm going to say how you can gamble in the law, and again, to the point of the show, how. In other types of litigation, how really mediation is the way to go. Because can you imagine you win and then some other people in black robes decide, no, you didn't win.
That's a case that I was 5 years before trial. I took the case to trial, won at trial, then it went up to the appellate court, and a year and a half later, the appellate court turned it over. So it's like, you don't know. I mean, that really does underscore, and we talk about this on the show all the time about wanting to settle the case. Right. And anytime that you go into litigation, it's a 100% gamble. Yeah. I'm saying no matter which type of litigation cases that you're in or what you think that have the odds going against you. I mean, I won plenty of cases that didn't get overturned. But here's the thing. When you not paying attention, or if you don't know what you don't know.
Yes.
Like, for example.
This is the point also.
So us foreclosure defense attorneys are doing pretty well, because of the issues in these foreclosure cases.
Right.
Now, at some point, I was able to tell my client, if the bank doesn't foreclose on you within 5 years of you not paying, there's a chance that you're not going to ever have to pay again, because there's something called a statute of limitations. Statute of limitations means that if a bank doesn't do something in 5 years after your date of your last payment, then there's a possibility that they can't bring it again.
They can't come after you again.
Now,
but let's speak. The statute of limitations will always depend on what? The case, the type of law.
The case.
Okay.
So if it's a fraud case, it's 4 years.
I don't want people to think
if it's a breach of contract, it's 5 years. In some cases, like for malpractice, it could be only 2 years. Mm-hmm. Sometimes in fraud, it could be longer than that.
So I want people to understand that statute of limitations will always vary.
Every statute of limitations varies. But in 2016, I'm going to show you how things, like you think that you know something and you want to talk about uncertainty. In 2016, the Florida Supreme Court came out and said, essentially, that the statute of limitations doesn't necessarily apply to foreclosure cases. So we could win and then win and then win and then win, and then the bank can reforeclose and reforeclose and then reforeclose and reforeclose.
Wow. So what then, Jay?
Okay.
Like what happens
So
to people then?
Okay, it gets worse for us defense attorneys because later down that road, when we won a case, the benefit of winning a case like that is that we
Can
talked this
recover
on the
attorney's
you can
fees.
recover attorney's fees. We talked this
Right.
on the show last time. Now,
Right. That was the golden nugget of last
that's
show.
a golden
attorney's fee
nugget of last time, and I'm just
provision.
going to take a 30-second segue into that. An attorney's fee provision in a contract allows the prevailing party to get their attorney's fees if you win the case or if you win the legal dispute. It's critical for you entrepreneurs to make sure that in your partnership agreements, in your NDAs, in your LLC operating agreements, even. I mean, if there's a dispute between the parties, you want to make sure that it's going to be resolved, that the prevailing party wins. Because you don't want to be in a position where you have an expensive legal battle and there's no attorney's fees on the other end. So the number one thing that people leave out is the attorney's fee provision.
Right.
But to get to back to this foreclosure piece, one of the appellate courts here in Palm Beach County, actually over Palm Beach and Broward, the 4th DCA, said that you can't get attorney's fees anymore if you win the case if the bank doesn't have the note at the time of the filing of the case. Now, that has gone up to the Florida Supreme Court, and they issued an opinion that's not very clear on the issue. Okay?
Right.
Now,
Another mystery of the law.
So
How can it not be clear? As a layperson,
so what had happened to me?
That's maddening.
What happened to me in representing these clients for years? I had to become more resourceful. I had to look deeper into the case and say, well, what's going on here that I'm missing that maybe provide my clients some relief?
Right.
And I started to dig into these cases, and one of my clients had a judgment against him in 2014. Mm-hmm. And I started getting, and continued to get, mortgage statements.
Actually, don't you still get
In
them
some
to
cases,
this
I
day?
still get the mortgage statements. I don't get it. So that I looked at.
But explain to the people won't understand the relevance of that. So
Okay.
please delve
So
into that.
When you have a foreclosure and it ends, there's no more mortgage. Okay, with the final judgment basically ends the mortgage.
Right.
All right. So if you're getting mortgage statements after the final judgment or after the sale or after title's been issued, there's an issue here, and the issue is it could
Because why? Because the mortgage company is a debt collector.
Is a debt collector.
Correct.
Right.
So this is a very nuanced thing that people may not understand. And again, this is where what you don't know, you could
But this
cost
is
you.
where when I'm talking to other lawyers or I'm talking to clients, got to get more resourceful because there's always something that you didn't see the first
Right,
time around.
right.
And some of the stuff I was not seeing in my foreclosure cases, nobody was seeing their foreclosure cases, didn't happen till after when the Florida Supreme Court said, well, these mortgage companies can continue to do whatever they want.
Right. So you're getting these mortgage statements, and sometimes the client is still getting
Right.
the mortgage statements, even though they're represented by counsel,
Right.
which is also illegal.
Right. Well, it's illegal under the Fair Debt Collection Practices
Correct.
Act. How can you ask for a mortgage statement when there's no more mortgage?
Right.
So,
Okay.
so we started to become more resourceful, and then we began to dig deeper than that. Because when
Okay.
you're the underdog, okay, you got to get more resourceful. You got to dig deeper. You got to look deeper into those paragraphs, into the sentences. And because of my background in forensics, and because one of my former employers did practice in the area of fraudulent transfer and civil racketeering.
Okay, so we're going to get into that. That's some juicy stuff there.
No,
Right. I mean,
So
yeah.
we began to dig deeper into the banks. Okay, now this is a course from 2008 to 2016. Now going to 2017, started to dig deeper,
then in
and then
2018
dug a little bit deeper, and we started to notice some things.
Among them, the anomaly of also the figures.
Yes.
And also some very strange figures that show up on a mortgage statement,
With
correct?
these mortgage statements that my clients were getting after the foreclosure judgment had some very interesting figures. Now, those figures were wrong. I mean, they're basically attempting to collect a debt that didn't exist is one thing.
Right.
But then on top of that, when I started to
Compounded by-
notice that the numbers were wrong, I said, wait a second here. And we started to look into this. And we're continuing to look into this. And we're looking at a couple of people that are working together in tandem,
In concert.
and to send out a fraudulent statement. Now, on the back end of this,
In the hopes of what? To
in the
collect
hopes of
funds
No,
accidentally?
you know what's interesting? they didn't necessarily have to send it to the debtor, other than it went to a mortgage statement that they never had to get anyway.
Right.
But
So these are what, unforced errors?
I would say unforced errors, but I think it's deeper than that.
Okay, so I
and
want to
this is
hear the
something- we're
opinion. I
actually-
want to
we're-
hear what,
I'm
like,
not-
the juice of it.
So it looks like, to me, that you have mortgage service companies, some of them, looking to rip off the federal government.
Okay.
By overcharging certain fees on mortgage statements that don't belong there. And you trace this back to what the final judgment said, and you trace this back to what something else said. So I have a few cases right now. We're
Double
taking-
dipping.
Yeah, it's double dipping, but at the end of it, we don't know why. we can't figure out why the mortgage statement is still sent out, because it's kind of like the red flag that said, "Hey, we did it." We're taking a deeper look at that right now.
Yeah.
But I'm saying David always has the shot, even though the Florida Supreme Court came and wiped out this idea of statute of limitations. This was huge for you had hundreds of thousands of foreclosures. You had some of them, I forget whatever percentage it might have been, that were
Right.
actually
It
won at
was-
trial or dismissed past this 5 years, and then the Florida Supreme Court comes out and says, "No, we don't. We're going to extend this
So any
concept
thoughts?
of."
Any thoughts on the motivation for the Supreme Court? Because if you think about it, they're there for the people, but that's not really representing the people. If you think about it,
I don't want to.
because it was like a pass. I mean, I know you can't say, but I was just
I
curious
can.
if you had an opinion.
You can always say broad stroke. The most amount of money that's fun that contributes to the system is
Okay.
going to get the biggest breaks.
All right.
But I don't know about that. I mean, I don't say that about the Florida Supreme Court or
Well, of
any
course not,
particular
because
judges.
we have
Because
an
you know what,
enormous amount of respect
I'm going to tell
also.
you that
It's just
Chief-
unusual.
The Chief Judge Roberts had a point the other day, and he said, we don't have Trump judges and we don't have Obama judges. You know, we have American judges. And
Amen. Amen. That is a beautiful thing to hear.
And I read the opinion of the Florida Supreme Court, and I saw where they're coming from on this issue. Because on the other side of that, let's not forget this, and I'm going to be for what's fair is fair, is that my clients also had a mortgage, and they made an obligation to pay something, and they also didn't pay for some 5, 10, 7, years. Okay.
Agreed.
So
Agreed.
So if you're looking for a balancing act, and at the end of the day, how are we going to resolve this? Because this had the potential to impact so many mortgages.
So I wonder if maybe the decisions come because of systemic abuse, and this is something also that we get to be. We're responsible for that as a society, also.
I look
On
at
both sides.
Okay, but I'm looking at this from the David side, and I'm going to expect to be the underdog.
Mm-hmm.
So as the underdog, I have to be more resourceful. I got to
Right.
look at angles that no one else would look at. I got to try
Right.
legal theories that no one else would try before, because the system is the system. Like when I say the system is the system, you have the larger law firms, okay, representing the larger clients,
Right.
and they have 8, 10 lawyers that can be assigned to a case that can
Right.
that can churn and burn and paper the file, and that's their.
So what is papering a file?
In other words,
people will not know that.
Okay, they for instance, all right. I file federal lawsuits against banks that send out these mortgage statements, right?
Okay.
And when I send out these
Under the federal statute.
under the federal statute,
Okay.
when I send this stuff out, when I file the lawsuits,
Mm-hmm.
okay, the larger law firms represent the banks, and
Mm-hmm.
I will get, let's say that under this Fair Debt Collection Practices Act, the maximum statutory damages is about $2,000. You can get punitive damages, but you can also get your attorney's fees. So these cases are not like the largest. I mean, they can be. I mean, they can be in egregious circumstances, but not always.
Okay.
But what the work that I'll get on the other side, I mean, the hours. And I read a motion to dismiss over the summer. I got this last summer, not this summer, the last summer, from one of these large law firms, and this thing was 20 pages, perfect. I mean, a perfect piece of work as far as no spelling errors, grammar. The law sites were absolutely perfect. This motion to dismiss probably cost $30,000, if not more. Okay? The maximum value of this claim was $4,000.
Wow.
Okay, and it's like, it's not
So
just,
talk about a hammer to kill an ant.
it's a sledgehammer to kill a flea. It's sledgehammer to kill a flea. So when you have that power, this is the thought of like the solar practitioners. Like you know what, this will bankrupt my law practice if I
Right.
take them on, because they have 8 lawyers. So when I say paper the file, you get additional requests for production, objections to your discovery that most times would never be made, and you, as that person in the position of solo practitioner, you gotta have a different strategy.
So this is interesting. You're talking about a couple of things, and we touch on this, and we have touched on this in different shows before. So Goliath has a couple strategies. Not only are they bullying the client, right, your client, but they also end up really bullying you or the sole practitioner by papering the file and other methods that we can get to.
Let's take a break.
Yeah.
And I'll talk about that, about how Goliath's lawyers bully the little guy.
Yeah.
I got plenty of stories for that.
Okay. All right. So stay tuned with us. We'll be back right after this short break.
Farrow Law Firm, standing up to corporate bullies, using innovative, aggressive, and effective strategies to resolve disputes effectively and timely. Contact us at 954-252-9818, online at farrowlawfirm.com, and on Facebook at Farrow Law Firm. We look forward to being of service to you. You have been watching The Verdict with Jay Farrow and Janine Davis. If you want to call into the show, you can reach us at 888-565-1470 or write us live on Facebook at The Verdict. Now, back to The Verdict.
Good afternoon and welcome back after that word from your sponsor, us. No. So thank you for coming back with us. And Jay, right before we went to break, we were talking about how Goliath has its way with David, aka the client, and ultimately the solo practitioner or the smaller law firm.
I'm going to tell you that in my practice, I remember I've been doing this I've been licensed for 16 years and been in this work for 18. And I remember working for my first few law firms, and one in particular. And we were going through a cross motions for sanctions, and the lawyers were commenting like this: "You'll never see this again in your career. You know, it's good that you're working on this now because you get a little experience in it, but you'll never see this attack on lawyers. It's just really not heard of." But in the last 16 years, I have seen, and especially in my chair, where the strategy of the Goliath law firms against the flea, the David, the guy that got bullied to begin with,
right,
is to target me directly. Can you believe
right.
we
talked about this, and I have always, again, as the layperson,
the way that this happens,
lazy law.
Okay, this is the way that this happens. If I'm serving out a demand letter, which is what we do, I don't file my cases.
Right.
Off the bat.
Generally, correct.
I 99 times out of 100, I want to see if the case can get resolved before we ever get to court, because, like we were just talking about before, litigation is a crapshoot. I mean, it really is completely uncertain. I serve a demand letter. I serve my complaint. I tell the client, look, I've already done my homework. This is what this looks like on paper. I'd like to sit down at a mediation table before this goes to court. All right. What I'll get 9 times out of 10, if they're represented by a large law firm, is a threat to come against me personally under there's a rule that if a lawyer were to file an action
we've
that has
mentioned this before,
has
but
no
it's
basis,
worthy to
if
mention it again.
If a lawyer files an action that has no basis in law or fact, they're subject to sanctions by the court, and it's an extremely high bar. I mean, basically, you have to have no facts, no law to support your position.
Right. It has to be frivolous.
That's the standard.
Right.
That's the standard.
Frivolous really is what frivolous is. It no merit, no law,
Absolutely
no
no
nothing.
merit.
Correct.
Absolutely no
it's
merit.
basically a lie,
Okay.
kind of.
But the thing is this. A lot of lawyers in my chair would take that threat and run, saying, look, I can't.
Right. No one wants to lose their law license over a case.
They're going to file it anyway. There's really no downside for this tactic. I mean, I do a cross motion for sanctions against them. Sometimes I'll just file it for them. I mean, and I'll just bring it to the attention of the court that I'm being bullied. I mean, usually, when I get this, I'm gonna respond. But the thing is, most lawyers take a look at this and recognize a couple of things. One is, what if because there's a couple stories out there like how the heck did this get to this point, and a lawyer got tagged for this, and so they're reading these opinions. They're like, wait a second, well, what if this happens and it could be like a big deal.
Sure.
The other thing is, it's a matter of time. When I talked about papering the file, how Goliath
and
papers the file,
bandwidth, right?
So I'm fighting myself and defending myself personally, you know,
While also trying to defend on behalf of your client.
And the other thing is the psychological effect. Like if I know that something's like, you know, someone's going to be coming after me personally, I might not have my heart 100% in, or I'd be cautious. And I've been through this so many times. Okay, is that there is no boogeyman, all right? It doesn't exist. I know my cases. They have expert witnesses. I have my fact witnesses. I know what the law is. I'm going to file. If I do end up filing the cases, I'm 100% confident that I'm going to win, not just not get sanctioned.
Correct.
But the thing is that it's a tactic. It's a tactic that's something that I have to handle.
Right.
I have to take this into consideration and tell my client, look, this is what they've just done.
Well, it's interesting because there's no real creativity behind that. And again, as someone in the law practice, as a non-lawyer person, I mean, I have a bird's eye view and I see certain things, and it really fascinates me there's such an incredible lack of creativity.
There's no creativity.
There's such an incredible lack of really integrity, actually, if you think about it at the end of the day, because it's really lazy. I mean, I don't know what the conversation could be with their client that would merit such a thing.
I don't know so much lazy as bullying. Look.
Well, it's both, right? But it's lazy law, because instead of, going toe to toe, law to law, right? Because that's what lawyers do, right? They're just saying, well, let me just threaten you and bully you instead. I mean, it's a lot more expedient if you think about it, and it's lazy.
It's lazy. I mean, I don't know how creative you are if you shoot somebody in the head. I mean, you kill them. I mean, it's like a thing. Correct. It's like if you're looking to knock somebody off with something like that, is it lazy? Is it bullying? I mean, whatever it is. And sitting in this chair, you got to handle it.
Yeah.
And the way to handle it is to become more resourceful.
Correct.
In other words, dig deeper.
So, well, as you were digging deeper, and I think that this is a really cool segue into what you've now recognized as pattern and practices, and how you sort of have created a really interesting, I would say, web or patterns that you've seen in your cases, where you have the breach of contract, you have breach of fiduciary duties, you've got all of the different actions that you can do. So talk into that, because that's where the civil racketeering comes in, the civil conspiracy, all of these things, where, again, people think that they're just doing business as usual, but they don't realize they're actually practicing some really devious traits.
When I'm looking at a case now, I look at the inequities first. Mm-hmm. I'm looking at which side has the money, the power, the control over the systems and everything else, and I look at how the contract was breached. I look for the patterns. Underneath the patterns, you're going to see different people working together, and it's amazing what people think that no one's going to see.
Right.
I mean, so
because people don't know that that's what they're doing. Like, if they knew that what they were doing is actually civil racketeering, they might think twice about it. It may not stop them, but they could think twice.
You know what? It could be that the concept is to not save money, but to make more money, to line their own pockets a little bit more, and they're figuring, hey, this is just, look, I'm in a position of this is my company. I deserve to get this extra on the side, and to get this extra part, because
I'm privileged. I worked 30 years to build it.
Whatever that is, I start seeing patterns. I see patterns where the principal of the company will be in business with, I call them the usual suspects.
Sure.
And the usual suspect, I mean, it starts like 10, 15 years where people are on the same corporations, on the same board of directors. There's the CFO of one company and then the CEO of another company. They're buddies. They work in concert. And then you start seeing, you start looking at this bank account, and then you look at all of a sudden there's transfers going from one company to the other company, and somehow all of a sudden you look on public records and one company that somebody else owned and has now bought some property, and then you start recognizing that they're stealing from their employees to do this. You know,
Right. So say more. Stealing from their employees, how?
Or they're stealing from their employees by, let's say, we have a case against Insurance Office of America.
Right. Oh, so shorting commissions.
Shorting commissions. Okay,
This is a number one way.
It's
Shorting
like,
commissions is
or
huge.
making a deal to do commissions in one way and not following through on the deal.
Right. So either way, shorting.
I mean, and there's some interesting stuff coming up in that case.
Yeah, I can't wait to
yeah.
talk about that when it's actually public record.
Right. Now, when I'm looking at this pattern, and you can see it, and it's all over the public records, and you see how people are working together, you can see similar to, identical to, if you ever see those, the FBI put up the pictures of the ringleader.
Yeah.
And then you have the you have the mafia, right? And you have the boss, and then you have the captains under the boss, and then under them you have and their captains they're captains of different crews. Well, you'll start to see how the head boss is really up to a lot of different stuff. And he's up to, like, for all different kinds of businesses. I mean, I have one case where this guy is into real estate, then he's into music and entertainment, and then he's into recording songs, and
construction,
and construction and architecture, and then you see the guy is in the center with a few other guys that are working together.
Right. And because he's got the realtor feeding him leads, and
So you start to develop this. So when someone comes to me and says, my partner ripped me off, I'm like, wait. Let's take a look at this. Let's look deeper. Especially they'll come to me like, let me guess. The partner guy was the money guy.
It's always the money guy.
And that's what happens. Is like you have the money guy and you have the doer. Like you have the guy that actually runs the company. You have the money guy who expects all of these things. And then the doer, doesn't necessarily think that he's got the voice to stand up to the money guy. And then the money guy ends up just working this guy to the bone.
Yep.
I'm saying in many instances that's the case. You start looking at that, you look at, okay, let me look at the money guy and see how he's operating. Because if he's shorting this guy in this circumstance to feed another business,
right,
and then that money's going into, let's say, this other business with these other few people, then I'm starting to see a web. And then when I start seeing a web, I start seeing what's called an enterprise, a scheme and enterprise of people working in concert.
Well, it's interesting, too, because we know from personal development and different things that we're interested in that the way you do one thing is the way you
do everything.
Everything, or at least most things.
Right. And that concept right there, that one sentence.
That's a nugget.
And nugget for entrepreneurs out there thinking about going to business with anybody. And I've just seen some recent posts with my attorney posts that are out there and my attorney's Facebook group about, they were asking about this investor that wanted to come in and make some commissions and whether or not this raised red flags. And I said, look, if you smell smoke, there's a fire someplace. There's actually an explosion. So just get ready for it. Right. All right. So for your entrepreneurs out there, it's like the price that you pay for not speaking up front is tremendous.
It's tremendous. And we're going to get into that at the other side of the break.
By the time you get into my chair and we're talking about this and we're saying, who's the money guy and let me find this scheme. Because listen, I love what I do for a living. I mean, I know that that we're doing really good work. We're doing really good work supporting some people to stand up to the bullies in their life. But if there's anything that we're really like to talk about on the other side of this break, and what this show is going to be about also is what you can do never to have to sit in my chair.
Right.
Because whether or not you sit with me or another lawyer,
listen, meet you for coffee, but not necessarily.
It doesn't have to be that way.
Well, and that's not true too, because you also do business architecture. You work in a happy way to create that, but you also are very dedicated to advise people how to avoid litigation. And this is what we're going to get into, and these are part of the tips of the day and the golden nuggets that you can go. And again, entrepreneur or not, all of these things could apply to you at some point because we all do business.
I had some feedback.
Oh,
just last night. So I'm going to attempt to be a little bit more lighthearted on the other side. I'm very passionate what I do. Look, when it comes to the law and supporting people to stand up to the bullies, I take it extremely. I'm very serious about it. Methodical. I'm obsessed with the investigations and supporting people to get what's owed to them.
Yeah.
Okay.
Definitely.
So
we're going to talk more about that on the other side.
On the other side of the break, we're actually going to add a little bit more what you can do to
stay tuned with us.
Avoid that.
See you.
Farrow Law Firm, standing up to corporate bullies, using innovative, aggressive, and effective strategies to resolve disputes effectively and timely. Contact us at 954-252-9818, online at farrowlawfirm.com, and on Facebook at Farrow Law Firm. We look forward to being of service to you. You have been watching The Verdict with Jay Farrow and Janine Davis. If you want to call into the show, you can reach us at 888-565-1470 or write us live on Facebook at The Verdict. Now, back to The Verdict.
Welcome back, everybody, for the last segment of our show. We are so excited to share with you the tips of the day. And we've got a couple of really good nuggets. So, Jay, take it away.
Some really good nuggets. Okay. This is one of the things we're going to talk on the show consistently. And if I can help it, I'm going to end the addiction to the billable hour for lawyers.
Right,
I'm going to
right.
say that again. I'm going to end the addiction to the billable hour. I think that it supports that system, and it's
Of the Goliath system.
and it's unnecessary. Look, there's resources that we have right now in the law as lawyers,
Right.
like legal research being one of them, that it doesn't take us 20 hours anymore to find what we're looking for.
Right, it's
It
an
takes us-
antiquated
it's
business model for a modern day lawyer.
Right. They
Right.
talk about like litigation. Don't be afraid to negotiate with your lawyer. Okay. There are alternative fee arrangements to the billable hour. So if you're thinking as an entrepreneur or anybody out there that's been bullied in the law and is like, how am I going to take on Goliath? And oh my God, there's someone's going to walk in and expect to hear I'm going to get a $15,000, $25,000 retainer. Depending on your case.
Right, there are some
But-
cases where
but
that's absolutely
there's cases-
appropriate.
but there's ways to break that up. You know, you should look for a lawyer that's looking to be resourceful and get you in and out and on with life. The case model, when you're talking about like retainers, yeah, it might be different if you're thinking about, let me get this guy
So why
through
don't you
this.
explain to people how retainers work? Because not everybody knows, not everybody has been to an attorney. So why don't you explain that
So
to people?
If you're doing a billable hour retainer, usually you give a certain amount, $5,000, $10,000, $15,000, and then the lawyer bills against that with their hourly rate. For everything, you know,
Everything.
the phone calls,
Phone call.
email, legal research.
Right.
I mean, and the thing is, it's an art; it's not a science. So there's a lot of things that get billed for, time that gets billed for. That it's,
Talk about that point.
Okay,
point
so
two,
here's, and I'm
you
not going to
know.
mention any names. or
No,
anything
it's
else,
not necessary.
But
We're
there's
just
a lot-
talking
there's-
about
Okay, as I've worked for,
generalities.
I worked for three firms, when I was in law school, and the billable hours, and this is from me talking with my friends as well, other law firms. We bill in 0.1, which is 6 minutes. Every 6 minutes we bill. So if you call me for 2 seconds and I'm like, pick up the phone and you ask me a question, maybe that's not it. But if I'm on the phone for like 30 seconds, I'm going to bill the call, because who knows what, a phone call from client. Then
Yeah, so you paid 6 minutes
6 minutes
when
on
it was a 30-second phone call.
right. So that's 0.1. So that could be a $35 phone call. Okay?
Wow.
Or if you're an associate, a $24 phone call. But here's the thing: if you're in a large law firm, then all of a sudden you write an email to your partner, telephone call with client regarding Ray this. Then they get it. Then they bill for that email.
Right, receipt and review.
And then you also prepared an email to partner regarding the phone call, so you can see where this goes. It's not an effective system,
Right.
and
And it adds up quickly.
But there's some firms, okay, that say 0.2 is where you start. I mean, there's nothing you can do
So
for less than
0.2 would
0.2.
be what, 12 minutes?
12 minutes. So there's really nothing you can do, because when you write that one sentence email, you're going to be thinking about it. You're going to be X, Y, and Z about
Right,
it. You know.
right.
And
So basically, you become a bean counter, because this is like very sort of like, wow,
well, the thing is that
that's a huge time suck in and of itself.
But here's the secret, right? You cannot bill 40 hours in a week. I mean, it's just not. I mean, as far as straight time, I mean, if you're working on something solid and appeal, something that, it's very difficult to get 40 hours a week. 50 hours a week is, But the way that you do that is the 0.1 and 0.2s. Because it's like, okay, quick email, that's 0.1. Da, 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 da. So you can actually,
Right,
in
right.
30 seconds or a minute, bill hours.
Right.
And that's
Okay,
the
so-
danger of the billable hour, is because it's susceptible. And when the young associates are in the law firms, I mean, I know that you have minimum hour requirements when you work there.
Yes.
And some they range
Right.
from the firms. They can be 1,800. They can be 2,400.
So again, I don't want anybody out there to think that this is the Verdict TV against big law
No.
firm. No. It's actually, we're talking about it, and and it can sound like an uncomfortable conversation, but it's really in service to both parties. Why? Because the larger law firms or anybody out there could start to think about it in a different way.
Absolutely.
It's a business interrupter. It's a discussion that brings about a conversation that is important to have, and also to educate the public. So that they can make a discerning decision.
I can get a client in my office, and I can say, okay, let me take a look at your case with the mindset that I'm looking to get them in and out and on with life. Not the mindset of licking my chops knowing that this is going to take 3 to 5 years and now I just put my kid through college. Because
Right.
some cases walk through your door, okay? I just filed...
We're ka-ching, ka-ching,
right.
ka-ching,
I mean,
as a billable hour attorney.
I just filed the case against Fly Victor, okay?
Mm-hmm.
It's a $30 million lawsuit, potentially a lot more than that now. It's like, if you're looking at it on the other side, it's like that's a million
Right,
two
to defend it.
in the next couple of years to defend it. If this is going down the tracks, because there's experts and there's this and there's that. It's in a foreign country. This is in London. So if the mindset though is, let me get my client and just tell them straight up, I'm going to get you through this case in 6 months.
Right.
To the best that I can, I'm going to get you through this case in 6 to 8 months, and I'm going to get you the best deal possible, because I'm going to tell you right now that the uncertainties of litigation, okay, are worth the haircuts that you're going to take in different areas. You're not going to get everything that you want. And I'll tell my clients this on their side when they're the plaintiff. You're not going to get everything you want. Okay, you're sitting in this chair. Okay, the likelihood of you knocking it out of the park and it going, yeah, it's possible. But if you want to think in terms of getting your life back
Right.
with what you deserved,
Well, and this is a distinction of your practice, right? Giving people the bird's eye view of, or a global comprehensive look at, okay, there is the win and there's what the win costs you
Right.
in terms of time, quality of life, sleepless nights, et cetera, et cetera. A lot of people don't necessarily discuss it in those terms. So it bears mentioning. And again,
could you imagine that though? Could you imagine that the lawyers, as we sit clients down and we are committed to,
I absolutely can imagine it. In fact,
urgency,
this is one of the reasons that this show has
Right.
been created.
because
the Verdict TV.
it's possible. It's possible.
It is possible.
to enroll lawyers into a mindset. Okay, because that business model, that grinding out 3 to
Right.
5 years of litigation. Okay,
Right.
in some cases it's going to be there. Okay, fine, but
right.
let that be there for some other cases. Let that be the exception rather than the rule.
Right,
Let
so-
let the actual filing the case be the exception rather than the rule.
Got it. So, but the point here and the tip of the day, just to sort of hone that in, is negotiate with your attorney.
You negotiate with your attorney. We're all people.
Ask powerful
We're all
questions.
people. Our fees are not set in stone. I mean, there are alternative fee arrangements. If you're the entrepreneur that has a startup, and you want to talk about anticipation, if you're the
yes.
entrepreneur that has a startup and you're looking to get a lawyer to be working on an LLC operating agreement, maybe you could offer to pay over time. Ask them what their flat fee is. Ask them if what are
If they'd be willing to work with you on a flat
If
fee.
they'll be willing to work with you on a flat fee. If
Right.
not, you can move on. I mean, there's not too many clients that say, listen, can you work with me on this? And I'm like, yeah, I can work with you because I can price it into the way that I work. Okay?
Right,
Because
right.
my concept is...
We very often do that. I mean, not all the time, not everyone asks, but when they do, there's a concession
There's
made.
no harm in asking. I mean, we're people too. Okay, if you come in and you have a startup, or if you've been bullied and say, look, I don't have what this takes, let the lawyer at least take a look at the case. You might not know. They could take it on full contingency if they see that the components are correct. I mean, and there's ways to work off a cost retainer where you're just fronting the cost as opposed to the full contingency. There are 1,000
Correct.
ways to skin the cat, ladies and gentlemen.
There are. So the point is really have a conversation, communicate with your attorney, give them the benefit of the doubt also too of wanting your business, being of service to you, and asking powerful questions.
And you can-
So, but to that point also too, Jay, you wanted to talk about anticipation.
Anticipation.
This is
Just like I was saying before, the drafting of a partnership agreement before a partnership starts and gets funded. I mean, is the number one thing that will save you
Absolutely.
millions of dollars. Could say it's not just the money, it's the time, it's the quality of life.
Yeah.
Okay, anticipation. Okay, give you another example. If you already have a business that's running, get a business audit by somebody that knows, let's say, employment law, or that knows employee contracts, or can look at your NDAs. Or how about you know what the number one mistake that business has made with
Tell
employees
us.
is their non-circumvent agreements. Believe it or not, it's because
speak into that. What
because
is
they're
that even?
drafted so broadly that they say, well, you can never work within whatever 250 miles in 7 years. In Florida, it's got to be so narrowly tailored to the actual like 50 miles, like in a couple of years. I think is what is something that's a good rule of thumb. Getting a business audit to go through your the stuff that you're regulated on. If you're in the restaurant industry, I mean, there's things that you
Oh
can
yeah,
do.
we've seen a lot with
But
that.
the thing with the partners, especially with the money person and then the non-money person, is to get the clarity. I mean, and to spend some time and to spend a little money up front. And even if
This is really an ounce of prevention. An ounce of prevention. So a lot of people, their way of thinking is we don't want to spend with attorneys now.
right.
And we guarantee you that there's a very large likelihood that you will eventually spend with attorneys when it goes sideways. Because when there is no clarity,
Right.
you will inevitably create
So we're going to keep
problems.
talking about these issues on the show. We're going to
Yes.
talk about inside the law, how lawyers can become more resourceful, how the concept of getting you in and out and on with life
Absolutely.
is the mindset that you should be looking for with any attorney.
So again, tip of the day, negotiate with your attorney and partner up and get it in writing.
Get it in writing. See you next week.
See ya.
Thank you for watching The Verdict. For more information about the show and your hosts, Jay Farrow and Janine Davis, please visit our website at www.theverdicttv.com or follow us on Facebook. The Verdict are live every Monday evening at 6 p.m. EST. See you next week.